Welcome to the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. Joining me now, as always, is Bloomberg News Editor-at-Large Bill Rochelle. You can check out his daily bankruptcy column available on BloombergLaw.com and also on the Bloomberg Terminal. Two really interesting items to go through today. Big news of the week, American Airlines has filed a Chapter 11 bankruptcy, making it the last of all the major airlines to file for bankruptcy in recent memory. Bill, the thing that jumped out at me with this case, there are no airports in the Southern District of New York. True story. Go check that fact out on Wikipedia. It's certainly a fact. How did this case establish venue? How did they get into the Southern District of New York if they don't have a business here?
That's a very good point. The same way that Eastern Airlines did, and the same way that Enron did. Neither of them had any operations to speak of in Manhattan, because you're right. The closest airports are in LaGuardia and at JFK, but guess what? That's not the Southern District of New York. That's the Eastern District of New York, so that wouldn't shoehorn them in. What they did was they had some tiny little real estate subsidiary named AMR Real Estate something or other, I forget what. That was the first company to file Chapter 11. Seconds after it went into the tank in New York, then the big parent corporation, AMR, filed Chapter 11 using the venue established by this little itty-bitty subsidiary.
Now, this subsidiary, is it enough to establish venue? Is it going to stick, or is this case going back to Northern District of Texas, where the company resides?
Well, good question for you to ask. It's possible that some creditor or creditors will file what's called a motion to transfer venue, meaning to move the case somewhere else, more likely than not, Fort Worth, which is closest to their headquarters at the DFW airport. Now, here's the deal. Venue motions such as this are almost never, ever granted in New York or Delaware. But this time around, there's a bit of a hooker, which people ought to keep their eye on. There was a bill introduced in Congress earlier this year in the House of Representatives that would end this venue method that so many companies use to get into New York and Delaware. And guess what? The chairman of the House Judiciary Committee and one of the two sponsors of the bill is none other than Lamar Smith, a Republican from Texas. And it is his constituents from Texas that are losing the opportunity to reorganize a hometown company. So, in other words, Lee, should a venue motion be denied here, this might engender some publicity and convince Representative Smith and others that maybe they ought to give some serious consideration to that venue bill.
Yeah, every jurisdiction, of course, wants these big Chapter 11s. They're good for the local economy. Bill, tell me about this, the substance of this case. How do you expect this reorganization to go? Is it feasible?
Well, it looks to me like they're going to move pretty quickly. They have already started to dump 24 very outmoded aircraft. And next up on the hit list, I suppose, is going to be first some more attempted negotiations with pilots and flight attendants, followed by motions to terminate the existing collective bargaining agreements. There is a little hooker here that the pilots should have kept in mind before they decided, shall we say, to not negotiate further, allowing AMR to file bankruptcy. And that is, the appellate courts in New York have held in the Northwestern Airlines case that if the bankruptcy court terminates the existing contract, guess what? At that point, the Railway Labor Act kicks in, and the workers can be enjoined from striking. So, in other words, in this bizarre Alice in Wonderland world of Chapter 11, the pilots could find themselves being forced to work for lower wages, and this is not something they would have faced had they stayed at the bargaining table and avoided this Chapter 11 filing.
Let's touch base on MF Global. This is an awfully big case. Lots of people are talking about it. Where are we today on that case?
Not very far. They are, by the way, on the cusp of distributing 66% of the $5.4 billion that customers are owed. But the big problem is, where is the missing $1.2 billion? What is intriguing me is that we are nearly a month into this case, and we still haven't been told how this money disappeared and or where it is. I'm drawing a couple of conclusions, and I can't wait to find out which is the right one. Number one, was this a, shall we say, thoroughgoing egregious fraud and theft that occurred perhaps just a few days before MF went into Chapter 11? Or, on the other hand, was there persistent, poor, or difficult or impenetrable bookkeeping, which has made these folks now unable to figure out where the heck the money is? If, in fact, there had been this sloppy, poor, difficult bookkeeping going on for months or weeks or years, then you're beginning to wonder, well, where were the regulators and where were the auditors while this was happening well before bankruptcy?
Quite a mess. Bill, thanks for that. That's Bloomberg News columnist Bill Rochelle. If you'd like to learn more about the cases or issues we just discussed, go check out the Bankruptcy Law Report available on BloombergLaw.com and also on the Bloomberg Terminal, as well as Bill's daily column. I'm Pacchia. Thanks for watching.